Hi, this is Josh Blackman. I am the president of the Harlan Institute, and I'm thrilled to welcome you to match number 2 for the 2018-2019 Harlan Institute ConSource Virtual Supreme Court competition. We are here to argue the case of Timms versus Indiana. We have 2 teams today. First, from Lake Oswego in Oregon, we have Rachel Lee and Cami Liu. And second, from Walter Payton College Prep in Chicago, we have Will Foster and Declan Davis. We are here to argue the case of Timms versus Indiana, and we'll begin in a moment. I turn it over to my colleague, Julie Silverbrook. What you'd like to add?
Just add what I always do, which is very best of luck to both of the teams. We've been really impressed by your briefs and your first round performance, and we're looking forward to seeing how you do this round. Good luck.
Thank you so much. All right, could the petitioners please take yourself off mute? And I have 15 minutes on the clock. You can begin whenever you're ready.
May it please the court that I, Rachel Lee, and my partner, Camelia Liu, will be presenting the petitioner in the case of Timms v. Indiana. At issue in this case is the incorporation of the 8th Amendment excessive fines clause through the 14th Amendment of the Constitution. Specifically, the incorporation through the Privileges or Immunities Clause or the Due Process Clause. In the case of Timms, we, representing the petitioner, contend that the excessive fines clause should be incorporated through the Privileges or Immunities Clause. But first, let us look at the facts of the case. After Indiana's arrest of Tyson Timms on charges of drug trafficking, Timms pled guilty and was sentenced to house arrest, probation, and $1,200 in fines. Indiana used civil asset forfeiture as well to seize Timms' $42,000 Land Rover under state legislation. Timms has petitioned the Supreme Court to hear his case, arguing that Indiana has violated the excessive fines clause. Now, let us outline why we, the petitioner, ask for the incorporation of the excessive fines clause through the Privileges or Immunities Clause in a 4-pronged argument. Number 1, staying true to history. Privileges or immunities' original intent was to provide a straightforward means of protecting both enumerated rights and unenumerated individual rights. Number 2, privileges or immunities refers to fundamental rights. Number 3, in this case pertaining to fundamental rights, privileges or immunities is a superior vehicle of incorporation than the Due Process Clause. And finally, number 4, the disproportional use of civil asset forfeiture is a state violation of the excessive fines clause.
Okay, Counselor, if I can interject briefly. So you're asking this court to rely on the Privileges or Immunities Clause. What has this court said in the past about the 14th Amendment Privileges or Immunities Clause?
That's a great question. Let's look back all the way to the slaughterhouse cases, which is the first thing anyone thinks about when the Privileges or Immunities Clause is mentioned. The slaughterhouse cases essentially guts the Privileges or Immunities Clause. In doing so, because the Privileges or Immunities Clause cannot be used anymore after Slaughterhouse made it so that the Due Process Clause took on the role that the Privileges or Immunities Clause was meant to serve.
Counselor, can I ask you a question? You said that the slaughterhouse cases gutted the Privileges or Immunities Clause. Can you explain to me how the case did that?
Well, essentially, it very narrowly defined the meaning of privileges and immunities of citizens to the rights that national citizens hold. For example, one specific right that they say the Privileges and Immunities or Immunities Clause protect is the right to access federal sub-treasuries, which again is a very strange kind of way to interpret the Supreme Court's, the framers of the 14th Amendment's kind of intent, which is definitely to protect the rights of citizens, especially concerning the rampant violations in the South in the form of black codes that was going on at the time. So it's strange to see that the Supreme Court interpreted a very narrow limitation of the privileges and immunities clause, considering the historical basis of and the multiple quotes that we will soon use in our argument that say that the privileges and immunities clause was meant to protect citizen rights and meant to augment the rights and prevent state infringement on these fundamental rights that we see as so important in our Constitution, and we see as so important as framers intended it to be. In addition to my co-counsel, because of Slaughterhouse, we see the augmentation of the due process clause, but we are going to be outright and say that we should overturn Slaughterhouse and we should ignore their decision and overrule that because.
Well, Counselor, let me just interrupt you for a minute, Can you tell me a little bit about stare decisis and how this court usually approaches the issue of standing by our precedents?
Yeah. Okay, so stare decisis is a judicial philosophy in which justices are inclined to follow judicial precedent. The argument that the question that you seem to be posing is that wouldn't overruling Slaughterhouse be a violation of stare decisis? However, there is a standard set by Janus, the state, county, and municipal employees, which was set in 2018, that recognized and embraced the weighty responsibility of the possibility of violating stare decisis. It presents the standard of a stable logical system for determining when adherence to the constitutional mandate. And it must be restricted and it must be on rare occasions because stare decisis is so important to the development of judicialism and how the individuals of America are affected by the decisions.
So, Counselor, can I ask you a question? Can't we just sort of avoid this whole stare decisis in line of inquiry by just applying the excessive fines clause through the due process clause, which is how we've done this traditionally?
If we do that, we run into the issue of basically abandoning the original intent of the framers of the 14th Amendment and also the original intent of the founding fathers of the United States of America. For example, we can look at the similarity in language between the privileges or immunities clause of the 14th Amendment and the privileges and immunities clause of Article 4, Section 2. We can see this kind of in a quote that is very widely cited in Congress at the time, also now. In Justice Washington's opinion in Forfeiture, where we see a similarity in language, specifically enumerating the rights of privileges and immunities, that's what it guarantees in George Mason's Virginian Declaration of Rights in 1776. So after that, also concurrently during the time of the ratification of the 14th Amendment, we kind of see the Freedmen Bureaus Act, which also, again, provides protection of unenumerated rights, and specifically the enumerated rights of the right to bear arms. So if we incorporate through the due process clause, we run into the issue of, again, as I said before, going against originalism, but we also face the contentious issue of, in this case, particularly with civil asset forfeiture, of having this very much roundabout meaning of protecting instead of straightforwardly saying these are the rights, these are the privileges and immunities of citizens of the United States, instead of saying, oh, because of this procedural violation or that particular point of avenue, which is pretty much absent in civil forfeiture cases, especially when it requires merely a preponderance of evidence and it seems the property is on trial and the burden of guilt is on the owner of the property rather than the other way around. So we kind of see this inherent issue of civil asset forfeiture in relation to privileges and immunities clause and the due process clause that we would need to incorporate exercise through the privileges or immunities clause rather than the due process clause.
So Counselor, if I could interrupt you for a moment, do you think this court's previous cases using the due process clause to incorporate were wrongly decided?
I believe that although Slaughterhouse should be overturned because of its flawed reasoning in violation of the Janus v. State County Municipal Employee Standards of quality, workability, consistency, development, and reliance, the further decisions of the Supreme Court using substantive due process to expand the first 8 amendments to the state should not be reversed because the use of substantive due process was just so important in the expansion of individual rights. And we cannot—
But why? Counselor, if those cases were wrongly decided, if those cases were contrary to the original meaning of the Constitution, why should we stand by them? If Janus teaches us that we should not follow precedents that are wrong as the original matter, why should this court continue to follow all the substantive due process cases that relied on you're saying what's an improper reading of the due process clause?
I would just like to clarify that we do not want to do away with the due process clause. We believe that the 14th Amendment, especially the 14th Amendment Section 1, is like a hand. Let's say that one finger is the citizenship clause, another finger is the privileges or immunities clause, the next finger is the due process clause, and there are 3 fingers, and then they all work together. Let's say a hand has 3 fingers, and obviously the most important finger of a human being is the thumb, and we believe that the most important part of the 14th Amendment is the privileges or immunities clause. In taking away the thumb in Slaughterhouse, the justices of the Supreme Court must contort the other fingers because of the loss of such an important and vital limb in deciding individual rights. And
so Counselor,
I'm sorry.
Totally get the analogy and appreciate it.
I like it.
I like it too. Let me ask you a question though. So you don't have you're saying you don't have a problem with the court's due process line of cases, but you think that we should now start using privileges or immunities as well. If that's what you're trying to argue, when do we use privileges or immunities, and when do we use substantive due process?
Well, I believe that in the cases of privileges and immunities, so as not to run into the issue on this human exclusion of non-citizens in the privileges and immunities clause, the privileges or immunities clause is best suited and in the interest of petitioners and respondents alike to apply to cases where citizenship is a factor. I would like to supplement my co-counselor's earlier point by an appeal to authority and a quote by Professor Eli, who is the former dean of the Stanford Law School. So he states that the purpose of the citizenship, privileges, or immunities clause and the equal protection clauses, and indeed of the entire 14th Amendment, was to secure equal citizenship, equal civil rights, and equal civil equality for all citizens of the United States. So looking at the context of the 14th Amendment and looking at what kind of the privileges and immunities clause, the equal protection clause, and the due process clause all cohesively do, which is, of course, protect infringement against rights that state governments or federal governments may do. So we see that the privileges and immunities clause is perhaps best suited to cases where we can augment citizens' rights while not.
Counselor, running a little bit short on time. Let me interrupt you briefly, if I may. Is there a textual difference between who's covered by the privileges or immunities clause and who's covered by the due process clause?
Well, the due process clause refers explicitly to persons, whereas the privileges or immunities clause refers explicitly to citizens of the United States, which we acknowledge is a very significant difference, but we also see that they are protecting different parts of rights. Different parts where the founders of the 14th Amendment, for example, John Bingham, was stating basically that the original intent of the 14th Amendment was to protect the rights of citizens, strangers, non-citizens of the land.
But Counsel, you have about a minute and a half left, so I want to make sure I get this point across. If we adopt your theory and we use a privileges or immunities clause, then that means, let's say you're a non-citizen, you're here on a student visa, for example. That means that the state can seize your car if you're a student just fine. There's no constitutional violation. Would that be the consequence of your position? You have about a minute left. You want to wrap up there?
It would not be the consequence of our position because we have found that all state constitutions and all state legislature, it applies to all persons residing within the state boundaries. It does not apply to all citizens. Therefore, even if the Privileges or Immunities Clause has the citizenship provision, it does not really matter when it comes to the individual state constitutions because all people are protected within the state legislature. And this protection of all people alike is also bolstered by the UN's Declaration of Aliens. And I think that's just another reason why the Privileges or Immunities Clause is perfectly fitted for the case of Timms v. Indiana, which is an issue of a fundamental right to property. Timms v. Indiana shows a clear violation of the excessive fines clause by the state of Indiana. The dire future possibility under due process is the state violates the individual rights, and those violations.
Okay, Counselor, you have time. You can finish your sentence.
Those violations being protected by due process is not a possibility that we want, and we want to protect against that by reviving the Privileges or Immunities Clause. Thank you very much.
Okay, it was a long sentence, but I think you got it in. Semicolons are good. Okay, if the petitioners can put yourselves on mute, please, and if the respondents can take yourself off mute, we'll switch to the team in Chicago. Okay, there's 15 minutes in the clock. You guys ready?
Yes.
Okay, you may begin whenever you're ready.
Thank you, Your Honor, and may it please the court. Today we will argue for the incorporation of the Eighth Amendment's prohibition of excessive fines against the states via the Due Process Clause of the Constitution. However, we will also argue that the forfeiture of Mr. Timms' Land Rover, which he used to illegally transport large amounts of heroin, was not an excessive fine as defined by the Eighth Amendment. First point. This court's precedents require incorporating the excessive fines clause through the Due Process Clause. Under Supreme Court precedent, the court is supposed to incorporate through the Due Process Clause all rights which are fundamental to the American scheme of justice. And I'd like to touch on the first point, which is that courts have historically used the Due Process Clause from cases in the 1890s with the Chicago, Burlington, and Quincy Railroad, all the way up to the 2010s with the McDonald case, which says, and I quote, "The question of rights protected by the 14th Amendment against state infringement is analyzed under the Due Process Clause of that amendment." And as indicated by the case of Arizona versus Rumsey, which is also only a few years old, a special justification is needed to depart from precedent as indicated by that case. As to the second point, which is that the Eighth Amendment is fundamental to the American scheme of justice, both the Duncan case and the Glucksberg case say that it is fundamental to the American scheme of justice and that it is deeply rooted in this nation's history and tradition. And also we see the origins of the Eighth Amendment's prohibition on excessive fines as far back as the Magna Carta, through the English Bill of Rights, the Constitution, the Bill of Rights, and even in 1868, 35 of the 37 states prohibited excessive fines. So it's clear that the prohibition against excessive fines is fundamental. And as we established with our references to Chicago, Burlington, Gitlow, Robinson, and McDonald, it must be incorporated through the Due Process Clause of that amendment.
So, Counselor, if I can just interrupt you for a minute, do you think that the Slaughterhouse case was correctly decided?
Well, under the judicial canon that the court should only answer the minimum number of questions necessary for case resolution, we don't think that we necessarily have to take a position on that. Suffice it to say that it is so old and there is no special justification to depart from that precedent that we do not think that the court should overturn.
I get that, but do you think Slaughterhouse was correctly decided? I understand we're judges, we have different considerations, but do you think Slaughterhouse was a correct interpretation of the 14th Amendment?
Yes.
More or less, yes. It was largely correct in that basically our historical analysis, we find that privileges or immunities is not most naturally understood to refer to natural rights. As far back as the Article 4 language of privileges and immunities, Professor Robert Nadelson has published detailed research showing that that did not refer to natural rights. It only referred to state-granted benefits. He says, quote, "The Privileges and Immunities Clause of Article 4 did not protect visitors in the exercise of mere natural rights. This was true even when those rights were enumerated in the host state's constitution. So it only protected visiting citizens in state-granted benefits, not natural rights." And because of the language of Article 4 and the 14th Amendment Privileges or Immunities Clause are so similar, we can assume that in both cases, they were not widely understood to protect natural rights, although it is possible that the framers had a different opinion, but framers' intent is not a proper method of interpretation under the original meaning. It must be the original public meaning that governs.
Well, Counselor, let me ask a question, right? We're not here arguing about some sort of unenumerated right, for example, the right of contract. We're talking about a provision of the Bill of Rights, the 8th Amendment, right? Excessive fines. And isn't there some evidence during the ratification debates that those who framed the 14th Amendment understood the term to include the first 8 provisions of the Bill of Rights, the first 8 amendments?
There is some evidence, but we also believe that there's also some evidence for due process incorporation as an original matter. For example, as scholar Stephen Halbrook has written at length, he believes that due process incorporation was intended as an original matter because, and I quote, "The Due Process Clause embodies the premise that life, liberty, and property are rights and that the people, not just citizens, hold them. There is thus a textual basis for incorporation under the Due Process Clause because a right of the people may be said to be not synonymous with a privilege or immunity of the citizen." And that also connects back to what petitioner was talking about earlier, where there's definitely a difference between protecting all persons versus protecting only citizens. And we believe all persons deserve protection by the Bill of Rights. And also, the Privileges and Immunities Clause, we mentioned earlier how slaughterhouse is very deeply rooted precedent. It's much more than a century old at this point. And just a few years ago, in 2010, in McDonald v. Chicago, 8 justices declined to accept the privileges or immunities theory that petitioner in that case had argued for. And the slaughterhouse cases were also found their holding confirmed throughout American history. For example, in 1908, in Twining v. New Jersey, the court said the Privileges or Immunities Clause of the 14th Amendment did not forbid the states to abridge the personal rights enumerated in the first 8 amendments.
So Counselor, what are then the privileges or immunities protected by the 14th Amendment? What are these rights?
The rights protected by the Privileges or Immunities Clause are generally, they would refer most likely to statutory federal rights. For example, most likely originally it was understood to include some of the rights mentioned in the Civil Rights Act, because as we said, privileges or immunities refers to benefits that are granted by laws rather than fundamental rights that have always been held. So like things like the right to make and enforce contracts or to sue or to testify are like more like benefits granted by law, and that's why they were found in the Civil Rights Act.
But Counselor, I mean, let's talk about Barron v. Baltimore for a minute, right? What was the holding in Barron v. Baltimore?
The Bill of Rights only binds the federal government.
And isn't there some evidence that during the drafting, the ratification debates, the framers were trying to turn Barron?
Talk about due process. So yes, but we think that a lot of that evidence can be read to suggest due process incorporation, as we quoted from Stephen Halbrook earlier, because again, we do not believe that privileges or immunities most naturally to the widespread public would have referred to rights. But again, even if it were true that the Privileges or Immunities Clause was originally intended to incorporate the Bill of Rights against the states, that would not necessarily justify overturning roughly much more than a century of precedent that has been built on and reaffirmed by the court as recently as 8 years ago.
Well, what if we don't overturn slaughterhouse? What if we just say going forward, we will use privileges or immunities as an alternate path for incorporation? We can say, I mean, look, think about it this way, right? Slaughterhouse referred to a right of contract. It unenumerated right. Well, if we say, well, slaughterhouse didn't talk about incorporation. I mean, what case was talking about incorporation? It wasn't slaughterhouse. Actually, was a different case. What case was that?
Are you referring to Cruikshank?
I am, right. So what if we just overrule Cruikshank? We leave slaughterhouse in place, we get rid of Cruikshank. Why can't the court do that?
Okay. There are numerous other practical benefits to preferring the due process clause over the privileges and immunities, practical in the legal sense, not practical in the policy sense. For example, non-citizens are not protected by the privileges and immunities clause, or most likely would not be. And as the court has explained in numerous cases, from like Sanchez-Llamas versus Oregon to Verdugo-Urquidez, the people of the United States includes more than just citizens. It also includes people who have a strong connection to the American community, long-term residents and other people who are economically and culturally bound to the United States.
All right, so let's talk then a little bit about the due process clause, right? It says no person shall be deprived of life, liberty, or property without due process of law. That seems like a very strange provision that would protect rights. It's about taking rights away with certain procedural protections. Why do you think that's a better way than maybe the privileges and immunities? What about the text of the due process clause lends itself to your theory of substantive due process?
Well, as we quoted from Stephen Halbrook earlier, we think it is plausible to read the due process clause as establishing substantive fundamental rights. And in any event, I think it's clear that that's at least a plausible reading of the text, because the Supreme Court has adopted it numerous times over the last nearly a century. They've adopted it in cases like Obergefell v. Hodges and many other cases. So, but even if it were not the best reading as an original matter, we would still ask that it be preserved on the doctrine of stare decisis.
Well, then, look. Oh, counsel, go ahead. Go, Justice Silverbrook.
I just want to I think we could spend a lot of time going down this rabbit hole, and I do want to give respondents an opportunity to take us through the due process analysis for this case, because we said excessive fines clause should apply through the due process clause, but that in this case it was not an excessive fine. Take us through that analysis, please.
Do you want to start talking about the same standard applies to states as federal government?
Well, first of all, the same standard applies to the states and to the federal government when we talk about due process and incorporation and the specific rights there. And this fine is not exactly excessive, because in rem forfeitures, if we were to imagine a proportionality requirement here, in rem forfeitures do not have to be proportional to the maximum fine in question. They have to be proportional to the involvement in the crime, as Justice Scalia said in one of our cases. Civil asset forfeiture and in rem processes are against properties, not persons. So in this case here, where Mr. Tim's Land Rover was intrinsically connected to the crime, in that specific case, the fine is not excessive because it is proportional to the involvement of the property. It is not proportional at all to the value of the property. So Indiana had the right to take the car, so it could not be used in further illegal activities.
And additionally, we believe that there's support in Supreme Court precedent for the view that in rem forfeitures are not punishments against the person, which are subject to the excessive fines clause under Austin v. United States, but rather are against the property. In United States v. Bajikajian, for example, in 1998, the court said, quote, traditional in rem forfeitures were thus not considered punishment against the individual for an offense, and because they were viewed as non-punitive, such forfeitures traditionally were considered to occupy a place outside the domain of the excessive fines clause. Now, we do think that there can be some cases in which in rem forfeitures could, based on the particular characteristics, be in fact punitive. But in this case, we do not believe that it was punishment, and therefore it's not subject to the excessive fines clause under Austin. you want to give some reasons why it's not punitive?
Well, in-rem forfeitures have not been historically considered punitive. I mean, stretching all the way back to England before the colonial era, we can see that governments have historically used in-rem forfeitures in order to seize properties that are engaged in primarily illegal smuggling. And that we can see continues through the 1600s, the 1700s, the 1800s, and even the 1900s, and then into the present day with heroin trafficking. And under our standard in Bajikajan, traditional in-rem forfeitures were not considered as punishment for an individual against the offense, and the Indiana criminal defense lawyers filed a brief which states that, quote, Indiana affords no protection for innocent owners of real property and minimal protections for innocent owners of vehicles. So it's obvious that this statute, as written, is not intended to be punitive, and moreover, the effect is not intended.
One minute left. If you want to just give a summary.
Okay, sure. So in summary, incorporation of the excessive fines clause through the due process clause is preferable to incorporation through privileges or immunities clause, because the latter course would be disruptive and unsupported by precedent. There's no good reason to depart, for no special justification to depart from the longstanding doctrine established by the slaughterhouse cases and repeatedly reaffirmed time and time again over the past century. Furthermore, historians disagree about what the phrase privileges or immunities meant at the time of the 14th Amendment's ratification. Historically, as Robert Nadelson has shown, privileges and immunities refer to benefits granted by law, not inherent rights. And in any event, there's still substantial historical disagreement about the precise scope of the privileges or immunities clause that would cause grave uncertainty were this court to adopt that course of incorporation. Moreover, the protections of the privileges or immunities clause apply only to American citizens, which could have catastrophic legal ramifications for non-citizens.
And that's time to give me a sentence.
That's all.
Yeah. Okay, very good.
There you go.
All right, if the respondents can please put yourself on mute. And the petitioners, take yourselves off mute, and you'll have 5 minutes for rebuttal time. You can begin whenever you're ready.
Let me emphasize once more that the privileges or immunities clause of the 14th Amendment is a superior alternative to the incorporation of the excessive fines clause, specifically referring to civil asset forfeiture to the states rather than the due process clause. The privileges or immunity clause must be revisited as it is a textually and more historically grounded jurisprudence versus the due process clause, which provides only complicated, contortionist workarounds in order to protect the original fundamental rights.
Counselor, sorry to interrupt you, but earlier you seemed to suggest that in some cases it would be appropriate to use substantive due process, and in other cases it would be more appropriate to use privileges or immunities. Can you take us through how we would determine which one to apply in different sets of circumstances?
Of course. We believe and we hold that the substantive due process was a legal fiction, as Justice Thomas noted in McDonald v. Chicago. Substantive due process was a legal fiction to take the place of the intended role of the privileges or immunity clause. Rather than distinguishing between substantive due process and privileges or immunities, which there is basically an in consequence none, we should make a distinction between procedural due process, which is its intended role, and privileges or immunities. Procedural due process will apply to the life, liberty, and property and the procedures of the state dealing with the protection of those three really fundamental rights to American democracy and society. And the privileges or immunities clause will take care of the more direct route to protecting the fundamental right to America, which is freedom. So although due process and privileges or immunities are both part of the same amendment that strives towards the expansion of the individual's rights, they are two completely and inherently different ways. And to bastardize the due process clause by adding substantive to it to make it seem like the privileges or immunities clause without actually being it, because of course the privileges or immunities clause is cast aside by slaughterhouse, that would be completely correct.
Sorry to interrupt you because you have limited amount of time in rebuttal. I'm still not clear as a court how and when we would decide to go one route over the other. Can you explain that to me? That's the analytical piece that I'm missing.
I see. Okay, well, let's talk about this case in particular. Civil asset forfeiture, in this case, was completely disproportionate to Mr. Tim's crime. The maximum fine for criminal offenses in Indiana was $10,000 for his Class B felony. However, his vehicle was forfeited from him, and it was worth $42,050.30, which was more than 4 times the maximum fine. So it is very clear that the civil asset forfeiture was disproportional. That is a complete violation of a fundamental right.
So what is the fundamental right?
The fundamental right in this case is the right to protection against the deprivation of property. And you might argue—
minute left, Counselor.
All right. As we kind of addressed, I believe that the respondents brought up that the public meaning of privileges and immunities at the time did not include a set of core and unalienable rights, which it clearly did if you look at dictionaries of the time, which I will not go into too much detail at. But they all basically said that they were synonyms of rights, synonym of natural rights, and synonym of fundamental rights. We clearly see that the privileges or immunity clause is a better, more straightforward means of incorporation, especially, as my co-counsel said, considering the violations, the rampant violations of procedural acts that civil forfeiture has allowed, meaning that most forfeiture is essentially less than the amount of $1,000, which shows us, of course, there's a disproportional impact, a disproportional intent in this protection. So we definitely need to incorporate excessive fines through the privileges and immunity clause because.
Okay, and that's time, Counselor. Thank you. Okay, petitioners, please put yourself on mute, and we will go back to the respondents for 5 minutes rebuttal, and you can whenever you're ready.
Okay. All right. So petitioners criticize substantive due process a lot in their rebuttal. However, it is not so clear as they argue that substantive due process was not supported by the original meaning of the 14th Amendment. Many scholars, for example, Ryan C. Williams, in his article, The One and Only Substantive Due Process Clause, have argued that even though the 5th Amendment due process clause likely was only procedural, by the time the 14th Amendment was enacted, it likely had at least some substantive component. Likewise, scholars like Evan Bernick and Randy Barnett have also found at least some substantive component to the due process clause of the 14th Amendment. And Kurt Lash has also found some degree of substantive component to the 14th Amendment's due process clause. So we think their attack on substantive due process is not necessarily warranted.
Furthermore, the petitioners have not seriously responded to our Arizona versus Rumsey special justification for overruling precedent requirement, which was reaffirmed as recently as Kimball versus Marvel Entertainment in 2015, which says that respecting stare decisis means sticking to some wrong decisions, and any departure from settled precedent demands a special justification over and above the belief that the precedent was wrongly decided. They have not provided such a.
What about Janus? They cited the Janus case a couple times. Do you think Janus was such a case where there was an adequate justification to depart from stare decisis?
Well, Janus, it did overrule a precedent, certainly Abood, but Janus did not in any way contradict the idea that there has to be a special justification. Janus very methodically spent many pages going through these issues. It found that that Abood was, poorly reasoned in certain ways. It found that it had been undermined by decisions. But in this case, substantive due process incorporation has not been undermined at all. In fact, it's been reaffirmed repeatedly. So many of the circumstances that led Janus to overrule Abood are not present here.
Oh, yes, and if we look at the court's history, whenever it has overturned cases, it has looked to certain specific factors, whether the case is practically or legally unworkable, whether it's been reviled in legal circles. And obviously, as my partner has stated and I've stated, that is completely untrue. Substantive due process has only been reaffirmed. And if we were to try and cut back on substantive due process, we would severely limit most of the many of the rights that we as a people cherish. The plurality in this case says that liberty finds no refuge in a jurisprudence of doubt, which I think highlights the importance of this here.
So you think slaughterhouse is like we should treat slaughterhouse like Roe v. Wade? Is that the argument?
More or less.
Yeah.
Yes.
Okay.
Yeah.
Good. You can continue, Counselor.
Oh, furthermore, overturning or getting rid of the due process method of incorporation or harming it in any way would put at risk the rights of non-citizens, which are crucially important today. As Sanchez-Llamas versus Oregon says, foreign nationals arrested for a crime, like anyone else in our country, are entitled to the panoply of Miranda rights, and presumably the panoply of rights in the Bill of Rights as well. We cannot have a system where some rights are incorporated through the Privileges and Immunities Clause and others through the Due Process Clause, because with the exception of certain very specific circumstances, the court has always held that non-citizens and citizens are protected equally by, are entitled to equal protection under the law.
Yeah, and also we disagree with their assertions that this is an excessive punishment or excessive fine, because under Bajikagian, again, civil forfeitures certainly have a reduced level of punishment.
Yeah, one minute left, Counselor.
Okay, and as Justice Scalia wrote in his Austin concurrence, the question is not how much the confiscated property is worth, but whether the confiscated property has a close enough relationship to the offense. Here, there's clearly such a relationship.
Yes. So the $10,000 limit that they keep talking about in their brief is a $10,000 limit on in-person fines related placed on felonies. This is completely different. This is an in rem forfeiture. It's an entirely different classification of things. It's basically an entirely different world relative to the criminal proceedings that were made against Timms versus Indiana. And finally, we'd just like to say that they make several practical arguments about how civil asset forfeiture can be considered unfair, unjust. But as Justice Scalia frequently said, it's possible for a law to be stupid but unconstitutional. And the practical benefits of civil asset forfeiture should be separated from the constitutional merits of the practice.
Okay, we're right on time. Thank you so much. Well, you are neither stupid nor constitutional, both of you. I think both teams did an absolutely wonderful job. It is so heartwarming and reaffirming to see the four of you put so much time and effort into studying not only the Supreme Court's precedents, but the history of the Constitution, the ratification debates. It's truly remarkable. I could have never done what you just did when I was your age. It simply was impossible. Julie?
Yeah, so I think every year the bar gets raised and the teams are better and better. And both teams made really sophisticated arguments and relied on scholarship and in some cases scholarship in cases that are fairly far outside of the realm of what we're talking about today. And I don't know that we would have even seen an argument like this in a law school moot court competition. You guys should be very, very, very proud of yourselves for how you performed today. So whether you advance to the next round or not, you're all winners because you did an incredible job today. You should be exceptionally proud of yourselves. I know that Josh and I are proud of all of you. Your briefs were great. And your argument today was really something to be proud of, again, whether you get to the final round or not.
I can say I agree without a doubt, without any jurisprudence of doubt, in fact. I will, you can tell we have fun. I will call this session to an order, and we'll report the results probably sometime next week or so. Thank you all so much.
Thank you.
Thank you.
Thank you. Thank you.